I'll let the state argue, and then I'll hear from Ms. Driver.
All right, thank you. Your Honor, first I'd like to address, I don't know that it's necessary, but in response to Ms. Trethewey and her commentary about trying to work this case out with the state prior to trial. The state has always offered the minimum sentence on murder, which was life with the possibility of parole. The state extended a plea offer for her to plead guilty but mentally ill to life with the possibility of parole. That was our plea offer and has been our plea offer for a very long time. The law does not permit the state to deviate from a life sentence for murder, and that was the minimum sentence that could have been offered, and that was what the state offered in anticipation of trying to resolve this case to spare everyone the trauma and burden of having to go through this trial. That was an offer that Ms. Driver chose to reject. Secondly, Your Honor, I would like to remind the court of sort of what we saw in the pendency of this case. Ironically, most of the emotional impact of the consequences of her actions came from people who didn't even know Hannah. Came from people in this community who had to respond to the consequences and gravity of her actions. We saw police officers, grown men, who silently wiped their tears from that witness stand as they had to relive that child dying in their arms. We saw grown police officers clearing their throats to try to maintain their professionalism and composure as they had to relive the weight and gravity of what she did. We saw the jurors openly weep for that child as they had to watch that body cam video of her life slipping away and had to watch the autopsy photographs of that baby and the manner in which she was slaughtered by her mother. We watched those people weep and have a visceral reaction to having to see that child in that way. And that was something that was done by Chloe Driver. Ms. Trethewey indicated that this was because of her mental health, but the undisputed fact is she's not in that condition now. She's in above average intelligence. She's perfectly competent. She's medicated. She's receiving care. Ms. Trethewey stood before you and said she regrets this every day of her life, and she doesn't necessarily openly express it in her chirps or in her phone calls. And I suspect what she's referencing are the chirps that the state served on the defense that she was sending during the course of her trial. During the course of her trial, where the rest of us were dealing with the burden and weight of having to advocate on behalf of that child, she's going back to the jail every night and having phone sex with her boyfriend, talking about what size penis she likes, how she likes rough sex, how she wants to be treated like a rag doll, how she wants someone to ejaculate in her mouth. We are all having to watch people fall to pieces over that baby in this courtroom. And she goes back to the jail and can't wait to have phone sex. It demonstrates what we know, which is a complete calloused indifference for the life of this child. The one person who should care about her. What is very clear is that Hannah Nicole Driver, at 13 months old, she could experience fear, she could experience pain, and she knew that that was her mother. And in the last moments of her life, that's what she got to experience. Panic. Fear, pain, and panic, as a knife was repeatedly plunged into her body. And the fact that the woman responsible for that action, in the condition she's in today, can go back to the jail after watching her child in that condition and send chirps such as, "I'm stressed, talk dirty to me," is appalling to the state. And it should be appalling to this court. And it demonstrates that she has absolved herself of any responsibility in this and not taken responsibility for the consequences and the weight and the gravity of her actions. It should be really clear to her at this stage what she did and what the weight of that is. And instead, she continues to behave like that. She continues to behave in a way that demonstrates she doesn't get it. She doesn't appreciate what she has done. But just because she has absolved herself of responsibility in this by saying it was her mental illness doesn't mean that the court has to absolve her of that responsibility, nor the law. As we sit here during the course of this trial, 4 years later, when she is perfectly stable and perfectly medicated, she continues to demonstrate a callous indifference for the actions that she caused and for the loss of that baby's life. And that is why the state is recommending a sentence of life without the possibility of parole. Because as we sit here now, she continues to demonstrate that callous indifference and that complete disregard for the life of that child that should be given the utmost respect. And instead, a bunch of strangers from Cherokee County had to be the ones to compassionately extend our hearts to that baby.
Ms. Trethewey, does the defense have any dispute about the facts stated by Ms. Grocker?
We absolutely
as far as
we do. And I'm going to preface this by saying I think it's pretty petty at this point, since we were served these at 4:30 yesterday afternoon with respect to this particular incident. They have absolutely no relevance to why we're here today whatsoever. The state can acknowledge, and I don't think they would disagree with me, that there are thousands of phone calls and chirps and text messages, including ones with that gentleman right there, that indicate that she was remorseful, that she was upset about what happened. There are phone calls, hours worth of phone calls of her crying on the phone, talking about what happened. The fact that she was talking, well, I'll say that she was talking to this individual on the phone for months leading up to trial. State has those phone calls. They serve those on us. She didn't talk about the case at that particular point in time because that's what she was instructed to do. She wasn't talking about the facts of this case. She wasn't telling this gentleman that she was getting away with anything or doing anything. She was not talking about the case because that's what she was instructed to do so. She is allowed to talk to people. She did so at the jail. She didn't talk about the case because that's what we told her not to do. The fact that she didn't say, oh, I'm upset about what happened at trial today, or I'm upset about what happened to Hannah on these phone calls, it has nothing to do with whether or not she was remorseful. And I'm going to say this, and I've kept my mouth shut about this for a very long time. I have an email from Ms. Robert from February of 2023. Ms. Robert and the district attorney's office sought out us to sit down and talk to Ms. Driver at the jail in an attempt to work this case out. I take issue with the assertion by the state that we categorically rejected the felony murder, guilty but mentally ill, life with parole option. What we have always strived for in this case was a reduction in the charge that appropriately reflected the mitigation that Ms. Driver suffered, the mental illness aspect of it, but I'll also go back to this email. This was at the request of the state to sit down and talk to Ms. Driver at the jail. This was also at a time where the district attorney's office was well aware that there had been communication for a very long period of time with Mr. Ben Michael at the jail. In that email, the purpose of this case, the meeting, was to determine what information Ms. Driver possessed about the criminal culpability of Ben Michael, aka Brian Joyce, which could be presented at a proper under oath under any potential plea of guilty that she may enter. The way that Ms. Roper is categorizing the plea negotiations in this case are inaccurate. The state, during that meeting, Ms. Driver told the district attorney's office and myself she was continuing to contact Mr. Ben Michael, provided them information that they didn't previously have, which subsequently led to the discovery of a bunch of other phone calls. Ms. Driver told them that. She was honest with them about it. What the state is not talking about here is the suicide aspect that was involved in this case, that the state was looking at this from all angles with the other people's involvement in terms of criminal culpability, but also with regards to her mental health. That has always been what this case is about. She exercised her right to trial because she has the right to do that. She exercised her right to trial because the state of Georgia, despite these plea negotiations and the evidence in front of them, did not want to recognize the mental health aspect and what we were asking for in terms of a lesser charge. Ms. Driver exercised her right to trial to show this world what that gentleman is like, what life with him is like, to put before this world that she is not the only victim of this person, and that in an attempt that maybe other people will be aware of what this involves. She has always accepted responsibility for the actions. We saw it at the hospital. We saw it with Detective Cruz. We've seen it in subsequent interviews with the experts. She has never denied what happened. She's never denied what she did and what she did to herself. And she understands what needs to be happen. At this point in time, Judge, the fact that she's talking to another individual is irrelevant. She's allowed to do that. They're not talking to you about any of the phone calls where she's been talking to her parents about what happened. There are plenty of phone calls where she's on the phone with her mom and her dad, hysterical in tears about what happened and knowing what it did to them and to everybody else that is affected by this.
The state has the right to conclude. Anything else that you wanted to say, Ms. Rock? And then I'll let y'all approach the lectern, and I'll hear from
I would
Ms.
just
Driver.
like to say that the defense's stated objection with regard to all of the sexting she was doing during the trial was relevance, not dispute as to whether it occurred. The state served all of those on the defense. It didn't find it necessary to read every disgusting message into the record, but the state's position is that her general moral character is admissible at a pre-sentence hearing, so it is relevant, and it also demonstrates a lack of remorse in terms of the timing and the context of when those messages occurred in relation to the days we were watching her daughter die on video and reviewing the autopsy photographs. That is the reason the state brought that information before you. So I would just like to make that clear.
All right, Ms. Trethewey and Mr. Kessler, if you want to approach as well. Ms. Driver, you can